Mr. Smith?
Good morning, Your Honors. May it please the Court, my name is William Smith. It's my pleasure to represent Mr. Bryant in this matter and to be here today. It's my first time here, so it is a pleasure. The crux of the issue here, I would suggest, the arguments by the government about probable cause and prejudice notwithstanding, the crux of the issue is whether or not the mere fact that the technology has changed, that would allow this court or allow the analysis to simply sidestep the statute, and I would suggest, as I did in my brief, that the statute here, the principles embodied in this statute truly are of constitutional derivation. Otherwise, what will be allowed to have happen is, in essence, a general warrant. A general warrant, the concept of a general warrant is not limited just to geographical scope, it's limited to temporal scope as well.
So you say 7 days?
The statute says 7 days.
Yeah, and
it says the return shall be made within 7 days.
And the return was made.
That's correct, but the return innately contemplates the return. A search has been completed. The return being the list of items as well.
No matter how many documents are involved?
Yes.
100,000 documents?
Yes.
Got to be done within...
Yes, and this reminds me of what Justice Scalia said recently relative to the line of cases dealing with the Confrontation Clause. Justice Scalia said, might be tough, it might be hard to bring in child witnesses, it might be hard to bring in witnesses in sexual assault cases, but that goes with the territory, and I would suggest that that same line of reasoning applies here.
Even where in modern times we have encryption and passwords and secret codes and all of that stuff.
That's correct, Your Honor. I would note in this particular case, and this was back in the late 90s, of course we've progressed a long way since then, but even in this particular case, the defense expert had offered testimony evidence that this could have been done within the 7 days.
Wasn't the search and seizure completed in a fairly short period of time? They searched for they got the warrant, they went into the house, or the office, they searched, they found the computer, they seized the computer, end of story.
They seized the computer. So it's not the end of story. Because the statute.
But for purposes of search and seizure, that's the end of the story, isn't it?
No, because, Your Honor, respectfully, the statute contemplates that the search will be completed within
But suppose, I mean, it seems to me that when somebody, say the search warrant allows them to take a file cabinet, okay? They take a file cabinet.
Correct.
And they put on the return, we've taken the file cabinet.
Correct.
Okay. Where does the statute say, and you can't look in that file cabinet anymore once 7 days have run?
The statute doesn't say that. The statute, however, does speak in terms of return, and my argument is that the return innately contemplates that the search will be completed by that time.
Say, that was exactly my hypothetical. He files a return saying we've taken the file cabinet, we've seized the file cabinet. I don't see why they have to complete their inspection of what is in the file cabinet at any particular time, other than to meet discovery obligations and other things in the course of the criminal case. But short of that, I don't see that there's any limitation imposed on when or how long you can look at and examine and study what it is you've seized.
Were it simply the case that it was examination study, or it's the Commonwealth's paradigm of sort of analysis, and the Commonwealth had analogized this to, for instance, to fingerprint evidence as well. But that's not the case here. What the case here was clearly by the lengthy testimony in the motion hearings alone established that what took place here was a protracted search. It took place over...
Well, excuse me, the warrant spelled out a bunch of things that are not normally in warrants.
Correct.
To deal with the unique circumstances that were posed, both by the nature of this, namely computers, the fact that it was a still operating law firm that was going to need this data back in order to continue to operate, and that you had attorney-client privilege matters. So the warrant put in all this additional stuff that doesn't normally go into warrants, or is usually dealt with separately from warrants. This one just happened to put it into the warrant. But it seems incredible to me that the judge who put those terms on the warrant knew that they were not going to be completed in 7 days. The master wasn't going to make that review in 7 days.
I don't believe there's any evidence to indicate that the judge knew that. And again, there was evidence in this case where the defense expert had said it easily could have been done within the 7 days. What happened, it related to the procedures that were used. The expert, I believe his name was Mr. Farwell, had testified that at first he used a certain extraction procedure to search the contents of the hard drive, and then he found that that had produced too many hits. So therefore, he went and he used I believe it was like a WordPerfect viewer to check each and every file, which again goes back to your very pointed question, Your Honor. That's why it was a search. But in any event, there was testimony, there was evidence from the defense expert that this could have been done within days. It could have easily been done within.
Could the master's review have been done within 7 days?
Well, we don't really know. That is not.
Would anybody have conceivably contemplated
Not
the
when the
master's
statute-
review and the sorting out of what was privileged and not, and that all of that, which was part of the procedure set up by the warrant,
Correct,
was
Your
going to
Honor.
be
And I
completed in 7 days?
think in the most salient manner, the legislature could not have contemplated that. Maybe it's the time now that they do that. But the fact remains that the statute exists. Cromer clearly says that the prejudice or the probable cause analysis is live within those 7 days.
Well,
After
but
those 7 days.
isn't that, I mean, what about the Commonwealth's argument here that, yes, there is a constitutional underpinning of all of this, and that's to ensure that, in fact, a warrant is executed while probable cause still exists, so it doesn't dissipate. Here, it's executed promptly. Once the server is seized, probable cause is not going to dissipate because all the information is there.
Well, I'm not accepting that it's quite that simple. There are other principles involved, as I believe my brother had even acknowledged in the brief, or perhaps amicus had acknowledged, that it's not just the files themselves, it's the properties of the files, for one thing. And that's not necessarily going to stay the same. That can change. But in any event, Cromer tells us that beyond that 7-day envelope, it is no longer an issue. Staleness can look back to the contents.
Probable cause surely may dissipate, but as Justice Sussman pointed out, what was in the warrant was seized within 7 days. There was a return within 7 days. And what was then done thereafter was a further inspection to make sure that what was taken out of that server was consistent with a very long and precise set of rules that were unique to this situation. But it seems to me if we're looking at just strictly warrant returned in 7 days, the answer was it was executed promptly. There's no issue of somehow it being executed, it was stale or executed at such a point where probable cause could have dissipated. So I don't see whether
well, again, but the only probable cause, were it true that probable cause was the only sort of larger consideration here, there may be some truth to that, but it's not. I would suggest that the statute was written to embody the constitutional principle that the government simply cannot be allowed to sort of sit on evidence indefinitely. The same could be held true in the future with respect to a home or with respect to a place of business. We could say, well, the government simply seized it. They put yellow tape around it. They put an electronic barrier around it or whatnot, Your Honor. So what's the problem? Nothing's going to change in there.
But if what you say is true, then when the government seizes drugs and they send the drugs off to a lab, they may need to, it may take 6 months to analyze those drugs.
Absolutely, Your Honor. From my experience, it might take longer than that. But again, that's analysis. It's not a search. The substance is what it is. And that's a different category as well because there's
Why
no
isn't this
propriety.
analysis, though? This is analysis of the material that had been seized.
It's a search. It's an extraction of the contents of the hard drive. It's not the same as files. Files are there. They're in black and white. They're there physically. Dealing with the contents of a hard drive or a CD-ROM drive, a DVD drive, whatever the case may be, Your Honor, it's an extraction. And what was done here is a search process. I would suggest.
But it's not a search for Fourth Amendment purposes. It is an examination of what has been seized under the Fourth Amendment.
Well, I respectfully have to disagree, Your Honor. On these facts in this case, it's not. What was done here is all of these files were looked at by way of I believe probably what the file was clicked on. There was a WordPerfect viewer, and then the person looking through those files was looking to see if there was anything relevant vis-a-vis the documentation on the warrant.
Mr. Bryant, it might be that you...
Mr. Smith, Your
I
Honor.
mean, I'm so sorry, Mr. Smith. It might be that you might have an argument if, for example, all the files, hard copies, were unable to be removed from somebody's home and the police simply camped in the home and sat there going through the files. I have no idea about that circumstance. Usually you can take files out, things are not stuck there. But it's hard to see. I mean, you take it's essentially the computer, the materials in the computer, and the warrant is returned within 7 days. I mean...
But again,
and the backup copy was provided back to Ellis & Ellis, also within the 7 days.
That is quite true. However, again, one could, as I cited in my brief, there are treatises on this subject that have suggested that it's not quite that simple.
It's not simple. It's a question.
No, but respectfully, Your Honor, that what can happen? Data attrition can happen, and the properties of a file can be changed. Certain files, when they're extracted, subsequent to that, copy given to the defense. Certain files, when they're extracted, there can be problems with them. And in order to try to sort of resurrect the files, the treatises say, the government has to then sort of cut and paste between the files.
And could I ask you, then, how would forcing the government to do this in the incredibly short time frame of 7 days help reduce the kinds of errors you're expressing concern about? It seems to me it would only make a bad situation worse if people had to go in and do this under such extraordinary time pressure. The whole point is that it is tricky to do. It is hard to do. It has to be done slowly and carefully.
That may very well be the case, but again, we have this statute. If that is the case, then the legislature needs to change the law to keep up with technology.
Do you disagree that most of the cases and federal cases that have looked at this issue of the searching through or analysis of whatever you want to put it, of computerized data is something that does not have to fit within the federal 10 days or other periods?
Thank you for that question. My brother had cited there's a very recent case on that. It was a federal case, United States versus Cyphers. Now, a couple of things about that case. It's very strange. The issue there was the 10-day rule, if you will, under the federal rules of procedure. It's not a statute. But the court there held that it really didn't matter because it didn't apply because it was a question of state officials conducting the search. Nevertheless, the court then went on, I don't know why, to discuss this whole sort of discussion that we're having here today and that my brother and I have raised in our briefs, number one. But number two, again, the constitutional dimension of this, to my knowledge, has never been decided by the United States Supreme Court. And there is, that I'm aware of, there's no federal statute dealing with it.
And you're saying there's more than one constitutional dimension. One is that there be probable cause to believe that the items to be searched for are in the place to be searched. And that clearly can be resolved here. That's not really an issue, is it?
In the abstract, I agree with that.
All right. So what the other constitutional issue is simply the prolonged deprivation of property?
Well, it's somewhat, but I wouldn't place it as just simply a person, when those items are seized, whether it's computers, files, et cetera, various laws in our Commonwealth contemplate the ultimate return of those items, unless we're dealing with a situation where it was, for instance, contraband. So to say that simply once that seizure takes place, the person has no interest anyway, or the entity has no interest anyway, I would suggest is just contrary to our statutes, it's contrary to our common law, it's contrary to our Constitution.
But you got a backup file.
Evidence is normally, in fact, held awaiting trial. People's clothes, people's cars, people's, things that are material. True. In fact, the Ellis & Ellis defendants got something much better. They did, in fact, and the court took pains to make sure that they were not immediately put out of business by this seizure, made sure that they had a workable copy back in their hands within a matter of days.
True. But a copy. And the fact is that the computers belong to them. The computers were in the custody that entire time. And the original files, again, so an attorney's original files are what they are. They're their original client files. And they're cloaked in of course, the presumption of attorney-client privilege. And I would suggest it doesn't suffice to say that because the copy was made, therefore, it satisfies the sort of policy, if you will, the constitutional policy behind the statute at issue.
Well, the second property you're talking about, the sort of deprivation of property, that seems to me to be strictly a reasonableness analysis.
Well,
Was it reasonable what the Commonwealth did with the property, how long it took them to inspect it? And I think on these facts, it clearly was. wasn't
well, even as accepting, again, I go back to the statute, I go back to Cromer, but putting those aside, even accepting that framework, Your Honor, as I cited in my brief, even accepting that framework, that's not what happened here. The motion judge basically found and basically deferred to what the expert had found. There was no sort of weighing what was the industry standard at the time, what was the state of the art or the state of the technology at the time. No such endeavor was made by the motion judge. So even if that framework is to be accepted by this court under those circumstances, I would suggest, it simply is not what was done here.
Thank you, Mr. Smith.
Thank you very much.
Mr. Lieber?
Good morning. May it please the Court. I'm David Lieber for the Commonwealth. Commonwealth asked for direct review here to urge the Court to reject the per se 7-day rule that the defendant has proposed for the analysis of seized computer data. As I think the Court has gotten a sense from Mr. Smith's argument, the per se rule would very seriously interfere with investigation of crimes that use computers to store data or to be committed. In fact, as I think my brother acknowledged, it would make such investigations impossible in some circumstances. That, and certainly would prevent the kind of careful, thorough investigation that was done in this case. The better rule is the one that Justice Osman has proposed, which is once the computer has been seized, and certainly once what was done here has been done, in other words, the data has been copied, it's been preserved in a form where it can be shown mathematically that it's identical at any future point to what was seized on the day, and a copy's been returned to the defendant. There's no interest that's served by the policy.
Mr. Lieber, let me ask you this. I understand that everybody's trying to put this into a theoretical framework which is consistent with both the words of the statute and our prior jurisprudence. But if there's a search warrant to search, a home for a particular object, and the search warrant is executed, and the government keeps the object, that doesn't mean that the warrant hasn't been returned to the court, has it? The warrant gets returned to the court and says, these things were taken, correct?
That's right.
Well, if you take a computer, take the computer.
That's right.
Right?
Yes.
Now, it seemed to me that in this case, for whatever reason, perhaps as a matter of discretion, perhaps not, the motion judge or the warrant judge,
yes, Judge Cobb,
was working out that this has, severe impacts on two things. One, attorney-client privilege, which is very serious in the context of a criminal case, and two, an ongoing business.
yes.
Right? I don't know what the cases are where if you want to seize all the milk cartons, you literally take all the milk and all the milk cartons and all the label. I don't know about whether you can take all of those, correct? But why do we have to get into hypotheticals about saying that this is an unusual set of circumstances?
I'm sorry. I don't believe that it is a particularly unusual set of circumstances. I think the thing that's unusual about it or novel is that it's difficult to come up with a perfect analogy for what a computer is. My suggestion is, at least in this case, there's a very clear analogy, which is just the paper client files that were taken and sealed and not read until several months later.
I ask because I look at the very, very first sentence of the judge's very thoughtful, lengthy findings of fact and rulings of law. I hope I've got the correct document. It said, this matter comes before the court for a resolution. The defendant's motion to suppress electronically stored evidence seized from two separate searches of their computer system, the first of which occurred on May 2, 1996, and continued off-site until right?
Yes,
So there's an assumption that the search continued off-site.
that's correct.
Could the search simply be seen as take the computer?
I think that it can. Justice Bone
Then
did.
why does the judge assume that the search is continuing as opposed to something? I mean, search used in that sentence for constitutional and statutory purposes, as opposed to analysis or reading the files or whatever it is.
I think Judge Bone was very careful to make sure that he used a very protective standard.
But let me ask you this, and now I'm asking you, the Commonwealth as an, as an officer of the court, if we were to hold, these computers could be taken, correct?
Yes,
Not all computers can be taken.
that's correct.
I mean, probably in this day and age, all computers can be taken, but at some point you couldn't take them an IBM mainframe, right?
Right, yes,
But now you've got a personal computer or PC or, whatever you've got here.
yes.
Was it the computer or the server?
It was the server that was taken, but it's,
But you can take it.
and it was in fact taken. It's a
It was
portable
identified in the
box that was
warrant
taken.
as within the scope of what you could take, and you took it.
Right.
That's right.
So if we don't just do a straightforward, this is one of those, you took the computer, you took the server, and then you did the analysis off-site, and you gave the defendant, if they were, I assume, if they hadn't been indicted, the party
The owner,
who's,
yeah.
had been searched, as much back as you could to permit them to continue their business. What would I be missing here?
I don't think that you would be missing anything, except that I think Justice Bone was concerned, probably mostly for privilege reasons, about trying to limit the scope of the off-site search
Yeah, I mean, it
to
seems-
those.
No, I
It seems to me
understand that.
what's happened here, and what seems to be confusing, is that those protective procedures got put on as schedules or addendum to the warrant, which, at least technically in my mind, that's not where they belonged. The warrant should have issued as a normal warrant. You can seize these things.
And then a
a
protective-
separate order saying, I'm going to place certain
Put it this
limitations
way.
on what you do with what you seized because of these other interests. I think, excuse me, the mere fact that they ended up in the warrant instead of as a separate order shouldn't muddy the analysis, the simple analysis that the Chief has proposed. The warrant authorized the seizure of these computers. That was done within 7 days. The return was made within 7 days. And all this other stuff that happened thereafter is not part of a, quote, search, but was an analysis performed subject to certain constraints that were placed in order to protect some additional interests that were very much at stake in these proceedings.
Which, by the way, you would have even if it weren't a computer. So, for example, if it
files.
turned out that your
And you did
livelihood...
in this case.
Yeah, but you could have your livelihood as a delivery man, and the government wants to take your truck. It may be that there's a search warrant to execute the search warrant, but then there's a protective order that says, in this particular case, the government must complete its analysis of whatever it wants to do, for fingerprints or bloodstains, whatever it wants to do within a certain period of time, because you've got a non-convicted person who's been deprived of their livelihood. I mean, that's okay, isn't it?
That's certainly okay.
Sure.
Yeah, what about, what doesn't trouble me, just confuses me a little bit, is that the Commonwealth went back for another search warrant for stuff within the server. Why was that? Because it wasn't covered in the first, so there obviously was a continuing, or another search of the material.
Well, I think it's fair to say there was a concern that a court like this several years later might think there was a continuing
everybody's
search.
belt and suspendering these, right?
Yes.
And all we need to do is to say the belt is fine. The pants
I
are not
agree.
going to drop down if you don't have the suspenders. Is that?
Exactly, and that's exactly why we're here. Your
The
Honor.
suspenders may be, and judges may need to be reminded that you have to have some protective orders if you're going to seriously disrupt or, be exposed to attorney-client material or, whatever it is.
So your view on this, though, is that that second warrant was unnecessary?
Yes, because the data had been seized, but it was necessary to get the judge's permission to violate the terms of the earlier, whether you consider the schedules to be part of the warrant or not. It would have been in contravention of the earlier order to print out those files.
As I interpret the statute, at least as we've articulated in Cloma, it's the following. You want to get, it has to do in part with staleness.
Yes.
You want to get a search warrant, and then you do not want the state sitting on a search warrant for 6 months, as it does all kinds of, and who knows what happens in between, and other people might have moved into the house, or there might be all kinds of other things. You want to make sure that you get the search warrant in a timely manner and that you tell a court within a reasonable amount of time, 7 days in Massachusetts, 10 days in the federal government,
Right.
Look, we asked for a warrant, we got the warrant, we've executed, we've taken what we needed to take, and here's what we took.
Yes.
Right?
Yes, I agree with that. And the important interest that's being protected is the putting a neutral magistrate between the target of the search and the search. And the neutral magistrate's probable cause determination is what's guaranteed by the Constitution. And in order to keep that probable cause determination accurate, it has to be served within a reasonable time.
Has to be served, and then you want the person who's serving it to tell the court,
Yes.
I did it in a reasonable period of time.
That's
so
right.
that you
And-
don't have any ambiguity, as anything. It's saying, get it, serve it within a reasonable period of time, and tell us that you've done it.
That's right. And this court said in Cromer that
That's what-
tell us about it is a ministerial act and is not a reason to suppress if that's important.
No, but it's a way of keeping this very, very invasive, constitutionally protected right that everybody has in check. And the legislature said, we're going to really make this a pretty tight one. You get it, you've got 7 days to do it, and then you better tell us. I mean, you've got 7 days to do it and tell us that you've done it.
That's right. And you can't serve the warrant after that period of time is what this court said in Cromer.
Yeah.
Is there anything you want to add on any of the other issues in the case?
Just that I think they're squarely controlled by this court's clear precedents to defer to Judge Bone's discretion. Thank you very much.
Thank you, Mr. Smith.
All rise.